Hello, everyone. Thanks for joining us, and I'm excited to have this conversation with everyone. My name is Yvette Valdez. I'm a partner at Latham & Watkins and co-chair of the Digital Asset Group, and I am joined here by this esteemed panel, Rebecca Rettig, Jake Chervinsky, Amanda Tuminelli, and Cathy Yoon. Before we get started, I want to just take a second to allow them to each introduce themselves, and then we'll kick off.
Sure. I'm Rebecca Rettig. I'm the Chief Legal Officer at Jito Labs. We build all sorts of staking and other infrastructure in the Solana ecosystem. And before that, I was at a number of other projects and builders in the space. I've been in crypto as a lawyer for 8+ years. Jake and I sort of started together doing this, and have been thinking about regulatory and policy issues unofficially and officially for about the past 5 or 6 years, just because I think once you started knowing the technology, regulators and policymakers were looking for people to explain, and so lawyers, for better or worse, were some of the people who they chose to do that. So yeah, happy to be here with everybody.
Awesome. I am Jake Chervinsky. I am Chief Legal Officer at Variant. We are a venture capital firm focused on early stage crypto companies across the entire industry. Before my current role, I was Chief Policy Officer for the Blockchain Association, which is the industry's main trade group in DC. So working with Congress and regulators to figure out what does good regulation look like for the industry. I'm now on the board of the Blockchain Association. It's also my honor to be on the board of the DeFi Education Fund, along with Rebecca, where Amanda works. So I'll turn it over to her.
Hi, I'm Amanda Tuminelli. I'm the Executive Director and Chief Legal Officer at the DeFi Education Fund. We are a nonpartisan nonprofit. We advocate for sound DeFi policy that looks like impact litigation, that looks like working on draft legislation, doing comment letters on proposed rulemaking, and really just showing up for software developers everywhere and anywhere that we can.
I'm Cathy Yoon. I am General Counsel at Wormhole Foundation. I probably don't need to go into what Wormhole does anymore after all the panels that we had today. I'm also on the advisory board for New York Department of Financial Services. Yay, New York. Yay or nay. And like Rebecca and Jake, I've been in the space for a very long time. And I think it's super exciting where we are today from where we started. But I think we still have a lot of growing to do.
Mm-hmm. Absolutely, and we're going to talk about that now. So there's obviously the direction of travel we're in right now is very different from the crypto winter that we all came out of. It's incredibly sunny and we're all getting tans. But I think that it's actually really important to sort of talk about that, right? Like, what does that actually look like for developers and technologists? Like, do we have carte blanche to effectively continue to build without any worry, given the regulatory headlines are no more regulation by enforcement? I mean, really, what is there to worry about? Jake, do you want to take this one first?
Yeah, sure. The short answer is no. We don't have carte blanche. The laws are still on the books, and we still have to pay close attention to figuring out how can we comply with laws and regulations that are really important, not just for mitigating legal and regulatory risk, but also for building good projects that people are going to want to use for many, many years to come. And this is a question I get all the time in my day job working with founders in my portfolio who are pre-product. They're trying to figure out, how do I launch something that will mitigate my legal and regulatory risk? And so I'll give you the short version of what I tell them, which is things are very different from how they were 6 months ago. Enforcement risk is significantly lower from agencies like the SEC, which was saying 6 months ago that basically everything in the crypto industry was in some way a violation of federal securities laws. That's not the situation we're in right now. However, the law has not changed at all. We do not have new regulations on the books. We do not have new legislation through Congress. And what this means is there is still significant legal and also regulatory risk. A lot of that comes from private plaintiffs' class action lawyers who are filling the gap that regulators are leaving, filing lawsuits against companies that can be just as damaging or destructive as a regulatory enforcement action. And the other thing is, if you want to build a product that's going to survive for the long term, you need to know what the regulations are, and you have to build to spec to meet those regulations. And so what I tell founders is, you should be aggressive, and this is a good time to be risk tolerant, but you also have to pay very close attention to what's happening in Washington so you can understand what the regulatory framework will be once it comes and make sure that you're building to comply with that framework.
I actually would say that I think it's more important than ever to think about where the regulations sit, because we're at a pretty important crossroads right now. I think everybody in this room is building in a serious way, right? We're at a fork. Are we building serious products for serious people that we want a mass group of people to use? Or are we just going to keep building sort of something where we were very constrained because we were all afraid of getting SEC subpoenas all the time, and so maybe you didn't have the most serious people always building the most serious products. And if you want to be on this path, which clearly everyone in this room seems to be on, and I think a lot of the industry is moving on the serious people building serious things path, then you do have to think about legal. You don't necessarily have to assume as a cost of doing business that you're going to get a subpoena from the SEC, because I think as lawyers, I certainly used to say that, like, just a cost of doing business, you're going to get it. Doesn't matter what you're doing one way or the other. And you should put aside, like a pot of money to be prepared to fight the SEC regardless. And so we don't have that anymore, but it doesn't mean that you should go out and be irresponsible. I think one of the things we have to do as an industry is also try to meet the regulators where they are in many ways, or show the regulators the path forward and take proactive steps to be transparent, to do a lot of disclosure, and to be responsible actors in the space.
Yeah, I mean, I think a few panels ago, Meltem said it was kind of open season and that she wasn't really concerned from a regulatory perspective. I love Meltem. I love hearing her speak. It's not open season though. I wish it were. My team comes to me all the time and they're like, we can let's go, full throttle ahead. We're gonna go and do these things. And I think I personally have said no more in the last 60 days than I have in the last 7.5 years that I've been in this space. And it's frustrating for me because I want to build, I want to move full steam ahead, but there is still a lack of clarity, unfortunately. And we have other existential risks and crises that we also have to deal with in addition to the SEC and other regulatory agencies.
And yeah, I would just pick up on that. I think one of those existential risks is the Department of Justice. Everybody is very concerned or talking about regulators and Washington being open for business. And not to be a Debbie Downer, but the Department of Justice has not given any signs of stopping their criminal prosecutions against software developers. So there is currently a pending case against Roman Storm, one of the developers of Tornado Cash. There is also a pending case against the developers of Samurai Wallet, and there are non-public investigations against other software developers for running unlicensed money transmitting businesses. And I will not bore you with all of the details of that.
Although one detail is important for DeFi protocols.
We will bore you with the details.
No, but for DeFi protocols, right? Like
Yes.
they're investigations of people who built DeFi protocols. Sorry, I think that is
for people building permissionless, non-custodial software are still being targeted by the Department of Justice for doing a thing that requires control over user assets. So the law for that is certainly on the books and has not changed, and unfortunately the DOJ does not seem to be changing anything that it's been doing recently.
So I think the takeaway here is proceed cautiously. But maybe we can do a little bit of aspirational, Amanda, and pivot slightly from Debbie Downer, because I actually think we've come a long way from November even. And as Cathy said, we've got a ways to go, but actually let's get into that. Where have we gotten to today from November, which actually is quite a bit despite not having legislation, and where are we going? So each of you, I'd like to hear what are the best achievements and what do you want to see happen in the next 2 years, since we really need to get all this done before midterms.
I wouldn't say it's the best achievement. I'm a little annoyed that the SEC's first guidance was on meme coins. But it's only because there were so many other things, and I get why it started with meme coins. It's easy. It's an easy give. They listed very specific criteria under which certain tokens are not going to be considered securities. I would love to see that with tokens that matter, and not just meme coins. But I think it's a great step. We're finally getting some real usable guidance as opposed to that horrible token framework that they put out in 2018 that was 80, I don't even remember how many prongs it was.
78.
78, right? I mean, where it was unusable, you couldn't do anything with it. They didn't weigh any of the factors. At least here, this was like nice, short, sweet, concise, and I would like to see more of that.
But we've got, I mean, from the SEC point of view, notwithstanding meme coin interpretation, right? We've got a crypto task force. We've got sort of this, we see the direction of travel on the SEC. What do you guys think about that?
Having been, I would say, the first industry participant, there were a number of trade organizations that preceded us, but having been the first company that went in to see the crypto task force, I will say, the direction of travel is really fascinating and pretty positive, and not positive like it's open season and we can all do whatever we want, but we are, notwithstanding Loper Bright, which unclear what that means for what the SEC can actually put out and uphold in terms of regulations, but we're going to get a lot more information. Yes, meme coins was easy, but they are taking a 180 approach. They want that from the last administration. I think the fact that every meeting is public, that you have to put something in writing, and they tell you it's going to be public, so you should know what it is, and that it's going to be out there. Like, this is definitely a sunlight is the best disinfectant kind of approach to things, and I think we're going to see a lot more guidance on a lot of the issues that we all care about, including staking, tokens, right? They have their first roundtable on tokens on Friday, so I think we're going to see a lot more from the SEC. And in terms of like what we have accomplished, I think we're looking a lot at the regulators and saying, great, we're so happy everything you're accomplishing, but I think the industry has to step back and say, we accomplished a lot. Fair Shake, whatever you want to say about it, the Fair Shake Political Action Committee was an extraordinarily powerful force in this last election, and that was really put together primarily by a few very powerful players in the industry, but really tried to bring people along in different ways. And so I think the industry really banded together to find a way to move a path forward, because I think 4 more years of what we had just endured was not going to be viable in any real way, and we weren't going to be able to build serious things with serious people.
I guess I'd frame it as 2 different things, the short term and the long term. And in the short term, what we've mostly accomplished is fixing problems and paying off debt created over the last handful of years. So there were some really quick wins that we saw very early on in the new administration. We saw the rollback of Operation Choke Point 2.0, right, the debanking movement. All of that just sort of wiped away. We saw SAB 121 replaced with SAB 122, so the SAB 121 rule wiped away. We saw the SEC dropping investigations and enforcement actions that took this very unreasonable, overly restrictive interpretation of the Howey test. So we saw these sort of quick and easy things that regulators were able to do that fix problems that were holding the industry back. That's great. It's all short term. The next thing that we need to do now, and by the way, we're basically out of short-term wins. I mean, maybe there's a few things left, but right now we're thinking about the long term.
Yeah.
So the question now is, how do we actually put into place durable regulatory frameworks that will survive another administration, perhaps on the other side of the aisle, that has a different perspective than this administration, or a different Congress with different leadership that has a different view from this Congress? And there's a few things that are happening. In the agency side, we have the SEC's crypto task force trying to figure out what does good rulemaking look like. I'm sure we'll see the same from the CFTC and from many other agencies, especially around how do founders create and distribute tokens with clarity that those tokens are not unregistered securities, really big issue. And then in Congress, we see 2 really major movements. One is for stablecoin legislation. I won't bore everyone with all the details. I think it's been discussed a lot already today. But there's nothing to me more obvious than that stablecoins are a better way to move dollars around the world than the traditional financial system. It's inarguable that this is an upgrade on the existing system. So that legislation should and I think will get done. And then there's market structure legislation, a much more difficult but maybe more important and impactful piece of legislation. How do we regulate the primary issuers and secondary market participants dealing with digital assets? And that's going to take a long time, but that's sort of the holy grail of what we're trying to get done.
Yeah.
Yeah, and I guess in the, Cathy, did you want to
No,
say
I mean, I was just going to say, I mean, we still have a long way to go, because, I mean, we just stopped at token issuance right now, right? And we're dealing with all of the entities or the players, the stakeholders that touch token issuance, asset issuance. So you have the issuer themselves, and then you have the exchanges and the custodians. But then you have these assets that are out there. What hasn't been touched on in any of the discussions is what happens when they're on chain. It's a whole new world, and none of the legislation really touches on what happens once assets are issued and they're on chain. I think maybe there is a supposition that they just go in and out of exchanges, and that's it. It's all for speculation. It's all for investment. But assets actually do things on chain, and I think that's another whole set of issues and conversations that we need to start having.
If I could just add one more win, I would say that from an educational standpoint, because part of our mission at DEF is to educate people about decentralized financial technology, is just the sheer amount of knowledge that has increased over time, especially in Congress and with regulators. So we had the first ever DeFi hearing in the fall where Rebecca and I testified and spoke directly to Congress about what DeFi is. I think that probably would have been unthinkable to you all a few years ago. So I think that it is a win that we're even having that conversation directly with Congress and with regulators.
Let's sort of double click on that point. I love that. I learned that like 2 years ago, and I use it sparingly. But anyways, when it comes to DeFi, right? Jake just sort of went over. We've got 2 stablecoin bills, one in the House, one in the Senate. We've got this digital infrastructure, this digital assets market structure bill that is going to be some version of various bills that we've already seen. In light of that, though, is the DeFi conversation completely absent? Like, where is the addressing of that evergreen approach that you talked about, understanding what the software and technology, the builders and the technologists' liability is? Where is it if we don't even see this being addressed in legislation? So where are we in terms of those wins on DeFi? Is it really just at education, or is it being addressed elsewhere?
So I would just push back on that just a little bit. I think that legislation is touching on DeFi, and sometimes unknowingly and recklessly. I think that market structure legislation could have the effect of making DeFi very impossible to build and exist in the United States if we're not careful. Hanging disclosure obligations or compliance obligations on technology, which is sometimes what a bill tries to do, or on software developers who have no ability to comply with those rules, would be very bad. So I would say that DeFi is part of the conversation, and we need more education so that we don't unknowingly make it impossible for DeFi to exist here. But we are getting there. I do think people are starting to understand like what base layer neutrality means and what making sure that tech being a neutral tool means. So I am hopeful that there's not going to be a huge loss with market structure legislation.
So I'll ask a general question. Anyone can answer on the views. Is it better to just get the market structure bill passed, even if it potentially compromises some of the important parts of DeFi, and sort of work around it later? Or should we potentially hold back? Because there's a bit of sort of at odds, the market, any sort of market structure bill that's really focusing on centralization and regulating these entities versus really the opposite concept of a lot of DeFi applications. Like, should we continue to push and support something so that we've got something on the books? Or are these bills and these laws a lot harder to change in the future?
We definitely should not compromise. And I don't think we need to, because traditional financial services, which are the proper target of this regulation, are fundamentally different from DeFi in the following way. A traditional financial service is offered by a company that has some different level of power in the system than the customer. This is the justification for regulation in the first place. It's that the user has to rely upon someone else to act in a certain way in order for them to get a financial service. Someone is holding their money, someone is conducting a transaction for them who has to get best execution. In some way, the customer is reliant on the institution to act a certain way, and so we regulate that institution to ensure that it is not acting for its own benefit at the expense of the customer. In DeFi, there are no customers. There are only users. DeFi is software that anyone can use to make their own decisions about how to use their own finances on-chain. And so there is no one to regulate in DeFi. Now, granted, if you're an institution that is packaging an underlying DeFi protocol in a way that does create this imbalance in power between the institution and the customer, that certainly can and should be regulated, but that's not what we're talking about when we talk about DeFi regulation. So when Amanda says some of these bills are capturing DeFi in an inappropriate way, it is regulating software developers as if they were offering a traditional financial service, even though fundamentally they are not doing so. And what we should do is fight as much as we absolutely need to in order to make sure that doesn't happen.
Yeah,
I was just going to say, I don't think anybody on this panel would argue with that. I think we also know how to regulate centralized intermediaries. We've been doing it for years. Other countries across the world do it. And so, fine, we may need to figure out, do we give the CFTC spot authority to regulate exchanges where they're trading crypto assets, which are just commodities and not securities. But other than that, we know what to do, right? You know about conflicts of interest, you know about best execution, you know about all of those things. DeFi, yes, we have come very far, but I don't think policymakers still really understand what a front end does, right? They still think it's intermediated and controlled and custodial, and those things are not true. So I don't think you can throw one in with the other. I think we do have to really be very clear about where the line is drawn.
So the answer, it seems as though, and this is what I'm trying to tease out, naturally somebody's trying to find the intermediary, right? And so they're always trying to find the technology. And I think going back to Amanda's point, which is this is about educating where the risks really lie and that we don't necessarily always need an intermediated experience in the financial services, and actually treat it separate and apart and actually understand those risks in isolation relative to sort of the framework that is not being adopted, which is a generally intermediated model, which is really where obviously the financial services regulation is coming from. So what's the answer? Making sure that by the time we get to passing these bills, we've successfully preserved the rights on the DeFi side so that these market structure bills don't actually by default capture the technology platforms.
Yeah, we're starting to, Wormhole Foundation, we're a Cayman Foundation. We're not in the US, but it's become really important for us to go to DC, to speak with members of the Hill, to engage with regulators more. And I think it's because we want to see good, thoughtful legislation that touches the entire space. And so some of the meetings that we had a few weeks ago, it wasn't to say don't regulate DeFi. It wasn't to say you shouldn't touch messaging or infrastructure. It was, we're going to introduce ourselves. We want to tell you what is being built, who's using it, why it's being done. And so when we give you comments on why certain aspects of your bill are untenable or should not be in there, that's the position that we're coming from. And so I think, you hear people talk about FIT 121 and saying there's going to be this legislation and it's going to be so great. And I feel like the Debbie Downer in the room. I'm like, we don't need any legislation. It has to be specific, it has to be precise, and it has to allow responsible building when it can happen. And so it's the same thing everyone's saying, right? We need legislation, but we don't want it to cover everything.
Yeah. Rebecca, let's go back to a good point that you made, which was, we are in a post-Chevron doctrine world. Mm-hmm. And there has been, and there's intended to be more regulatory clarity. In fact, that's what the SEC and the CFTC has stated, no more regulation by enforcement, but we're actually, going to give the market a heads up of what we think. What's the dynamic there? How much clarity can we expect the market to get in a world where really the regulators don't actually get as much deference as they did?
Yeah, so I'll take a step back and do a 2-second, 30,000-foot view of sort of what we're talking about from a legal perspective, which is Chevron was a case that the Supreme Court decided that basically said that regulators get deference, that their rules that were put in place are constitutional and can stand. Loper Bright was a case 6 months ago, I don't remember how long it was, last session in Congress, that rolled it back and said the regulators don't get deference, and it was really meant to curtail the expanse of the administrative state.
Last session, the Supreme Court. You said Congress by mistake.
Oh, sorry, last session of the Supreme Court, sorry, yes. And so the question now is, if it was really intended to curtail the authority of the administrative state and the regulators, SEC, CFTC, and others fall under that, what can they really do in terms of rulemaking and what kind of authority do they have? I think that the SEC is clearly going full steam ahead in at least putting out guidance. I assume we might see rulemaking, but I don't know if we'd see that until Paul Atkins is confirmed as the chair. But I think people are going to tread pretty lightly on rulemaking in itself. We saw tons and tons of proposed rulemaking in the last administration, some of which passed, some of which didn't, some of which just got rolled back. The SEC just said that they were not going to put the exchange rule in place. The exchange rule was meant to expand what constituted an exchange under the US federal securities laws and who had to register to scope in both DeFi protocols, but also L1 and L2 validators, and said that they would have to congregate together and come in and register as an exchange together, which was obviously very untenable and not workable. So I think we will actually see rulemaking, and I think it's going to be so narrow and specific that it just may not get challenged, but I'm sure other people here have more informed or different views than I do.
And I would make a point that in a Loper Bright framework, right, the idea is that you're supposed to actually have consistency across administrations. So part of what was being challenged is the fact that it didn't give regulatory certainty to these. It was a case about fishermen being charged fees for folks to come on to their boats, but the principle is that it doesn't give me consistency. Every time that the administration changes, the Democratic House is going to have a much broader interpretation of the rules. Republicans are going to have a much narrower application and interpretation of the rules. And we need some market consistency. So we really shouldn't be giving the regulators that much deference. And it's borne out and frankly helped the market generally. And frankly, the crypto market was actually more willing to challenge the interpretations of the SEC and the CFTC, and frankly, that'll probably continue to occur even more so now in the Loper Bright framework.
I totally agree, and I think importantly, the downfall of Chevron doesn't mean that the agencies have less authority to do rulemaking. It just means they have to do a better job in their fact-finding and their explanation because they won't get deference that their rulemaking is reasonable. This is very different from something like the major questions doctrine or the non-delegation doctrine, which actually say the agencies have less authority. It would be pretty interesting to see a flip-flop from the political perspective, whether those who were previously opposed to those doctrines now take them up to try to limit what kind of rulemaking can be done now. We'll sort of see if that happens. But I think all it means is the agencies have to do their jobs well, which is all we really ever wanted, right? I think the industry has been painted as wanting no regulation, and that is the furthest thing from being true. We want good regulation that makes sense that we can actually comply with, and I think the downfall of Chevron will get us one step closer.
And in the 90 seconds that we have left, I did want to sort of raise the question of the states, right? In light of all of this, do we expect the states to sort of come in with guns ablaze on crypto sort of legislation and regulation, or are they going to continue to take, a back seat in maybe only a couple of states? Anybody have any reactions?
I think that states are directionally very interested in getting involved. DEF, along with 18 states, sued the SEC last year because the states were interested in getting a declaration and clarity on securities laws and how it affected their state citizens. So I think the states are interested, and especially when it comes to DAOs. I know we're running out of time. I think with DAOs in particular, states have a lot of room to decide what, if any, legal wrappers they're going to wrap around DAOs.
I think to your point, the states are trying to get involved. I think there's been something like 200 draft bills or something crazy from all of the states on crypto and how to regulate it. So I think we would like to see probably federal law so that those can be preempted, and we won't have something like 50 money transmission licenses to have to deal with in the crypto context.
Yeah, I mean, I'm always secretly, I mean, the states issue is one of the things that actually keeps me up at night because there's so many. And you know, there is the unfortunate bit license here in New York, and there are other states who are looking to emulate that. And it's untenable, and you can't have projects dealing with federal laws and issues and then also dealing with 50 disparate states.
All right, awesome. That's a wrap. Thank you very much.
Thank you.
Thanks very much, panel.